Hi, Alicia Catherine Daniel, owner of Genesis Law PA, an estate planning and probate law firm here in Florida. If this is your first time visiting my channel, welcome. Please don't forget to like and subscribe so that you will be updated as soon as I upload new videos about estate planning and or probate. In this video, I'm going to talk about the different types of probate that we have here in Florida. The type of probate case that you will need for your loved one's estate is going to depend on the value of assets that have to go through probate. So the first thing you have to do is figure out what the value of the probate assets is. Your probate assets are going to be assets that are owned solely in the name of the person that has passed away and do not pass by either operation of law or contract. So an example of property that passes by contract would be a life insurance policy where a beneficiary has been named. In that instance, the life insurance company is going to cut the check payable directly to the named beneficiary. An example of property that is going to pass by operation of law would be, let's say, real estate that is owned jointly between two individuals, and it's either owned maybe by a husband and wife and both of their names are on the title, or it could be just two individuals, maybe a brother and sister who own, and the deed says with rights of survivorship. In that instance, the property is going to transfer automatically to the survivor. So now that we know what property we're going to be valuing, there are some exemptions. In other words, there are some properties that we actually don't count the value of when we're determining what the value of the estate is. So here in Florida, we are very homestead friendly. So regardless of the value of your homestead, we do not include the value of that homestead when we are trying to figure out the value of your probate estate. We are also entitled to 2 personal vehicles, which are exempt. So again, if you have 2 personal vehicles in that estate, they're going to be included in the estate, but we don't include the value of those vehicles for purposes of determining what kind of probate we're dealing with. And then in addition, we have $20,000 of household furnishings that are exempt. So if you have up to $20,000 of household furnishings and goods, we're not going to count the value of those assets. And then the last thing we have is a $1,000 personal property exemption. And your personal property is, I always say, just think of anything that moves. Anything that moves is personal property. Now that we know how to value our asset and specifically what assets to exclude from the valuation, you tally it all up and now you have an idea of what type of probate you need to file. If the value is below $75,000, then you can file a summary administration. A summary administration is a streamlined process. It's much faster. You are not going to have a personal representative appointed in that case. So if you have the type of estate where you have to have a personal representative, sometimes you need someone who is going to be authorized to sign documents or contact different entities. In that instance, even if the estate is below that $75,000 marker, you're still going to need to file a formal because you cannot get a personal representative in a summary administration. Another caveat when determining which kind of probate you're going to be filing, in Florida, if the person passed away more than 2 years ago, you also can qualify for a summary, regardless of the value of the estate. Again, if for some reason you need a personal representative, you will need to file formal, even though the estate qualifies for a summary. And your formal administration is any other probate that exceeds the value of $75,000 or any probate, like I said, where you're going to need a personal representative appointed. We do have a third type of probate here in Florida, and that's for really small estates. The full name of this type of probate is disposition of personal property without administration. And you can file a small case without an attorney. Most court clerks actually have the forms right there on their website. The caveat with this type of probate is it cannot be filed if there is real property involved. So if the person that passed away owned real estate and title needs to be transferred from the decedent to someone else, you cannot file a small estate. Another eligibility requirement for a small estate is the amount of assets, the value of the assets that you're trying to transfer out cannot exceed what you spent in funeral expenses. And there is a cap on that. It's $6,000. So as long as, for example, let's say they have $3,000 in a bank account and the funeral expenses that you paid were maybe $4,000, then you certainly can go ahead and file a small estate case. So let's summarize really quickly. Here in Florida, we have three different types of probate. We have disposition of personal property without administration, and that deals with your small estate cases. Then we have summary administration, which requires that the value of the probate assets must be below $75,000, or the decedent, person who passed away, must have passed away 2 or more years ago. And then finally, we have formal administration, which deals with any estate that doesn't qualify for your small estate or summary, but also any situation where you need to have a personal representative appointed, that is also going to be requiring a formal administration. If you are in need of probate assistance for the estate of someone who died either as a resident of Florida or owning property here in the state of Florida, click on the link below to schedule your probate consultation. Again, Alicia Catherine Daniel, owner of Genesis Law, PA. Thank you.